So we can start without further ado. We'll go to the preamble. Somebody's mic or head is there. Yeah. Okay, this is the preamble. These are the amendments that have been made in the preamble. And they're in yellow. So it says, we the people of Fiji, recognizing the indigenous people of the Itauke, the ownership of Itauke lands, their unique culture, customs, tradition, and language. And then that also applies to the people from Rotuma. And again, you have their unique culture, customs, traditions, and language. Then we have recognizing the descendants of the indentured laborers from British India, because that's where they were brought from, not India, and the Pacific Islands, their culture, customs, tradition, and language. And recognizing the descendants of the immigrants and settlers to Fiji, their culture, customs, tradition, and language. And the rest of it over here is what we already had in the draft. Declare that we all Fijians united by common equal citizenry, recognizing the Constitution as supreme law of the land, etc. So the amendments that have been put in place are highlighted in yellow. That obviously addresses a number of the issues that some people felt that the indigenous cultures or indigenous peoples weren't recognized. And thus you also have the fact that it's been set out as a unique culture, custom, tradition, language, because there's no other place in the world that has all of these characteristics. Also in the submissions, as you know, that we had a number of people of Rotuman descent who felt that Rotuma had been missed out completely and was not mentioned. So this is again recognition of that. And we'll come on to the issues pertaining to land and how that we've strengthened that. Indeed, we've given more recognition and protection for lands than ever before in our history for Itauke land, Rotuman land, and Banaban land. The next amendment or the changes that have been made has been section 2, more of tidying up but also securing the Constitution, setting out the technical aspects that any law that's inconsistent with this Constitution is invalid to the extent of the inconsistency. These are standard phraseologies that's been put in. It shall be upheld and respected by all citizens, Fijians, and the state, including all persons holding public office, and obligations imposed by this Constitution shall be fulfilled. Courts need to ensure that the Constitution are enforced through laws and conducts consistent with the Constitution, rights, freedoms, protected, and duties under the Constitution. Subsection 5, this Constitution cannot be abrogated or suspended by any person. It may only be amended in accordance with the procedures prescribed in Chapter 2 of the Constitution. Now, the next there's a couple of amendments that have been made. They're more technical aspects of rearranging words, so we don't necessarily have to go through that. But Section 5, essentially in the notion of citizenship, we've emphatically said that all citizens of Fiji shall be known as Fijians, in case was any doubt about that. All citizens, subject to the provisions of this Constitution, have equal status and identity, which means that they are equally entitled to the rights and privileges and benefits of citizenship. And when we said subject to the provisions of this Constitution, you'll see later on that there are certain, obviously, preferences given to Itauke, Banaban, and Rotuman people in particular regarding their land. Of course, in respect of the enforcement of certain customary practices, which we have also now included. The next amendment is in Chapter 2, page 11, which was the Bill of Rights. Now, we've set out quite clearly, and also in respect of, we received correspondence from the UN Human Rights Commission, where, obviously not all rights are completely without any checks and balances. There are certain limitations to rights imposed in all countries, and we've set it out clearly. Can you please go back up? Go up. Just go right up. Okay. So rights and freedoms set out in this chapter apply according to their tenor and may be limited by limitations expressly prescribed or authorized or permitted, whether by or under written law. So, for example, hate speech. So you can say freedom of expression. It doesn't mean you can go and say, let's go and kill all the Chinese. You can't do that. In the same way, limitations prescribed and set out in or authorized, permitted by other provisions of this Constitution. So there are certain limitations, for example, in the transitional provision. And limitations which are not expressly set out or authorized, whether by or under written law in relation to a particular right or freedom in this chapter, but which are necessary and are prescribed by a law or provided under law. The test is necessary. So, for example, if there is a certain limitation that's placed on a person's right, so if, for example, you have, say, freedom of movement, but if you have a disease and you need to be quarantined, so like bird flu, whatever disease may be, you need to be quarantined. So if you may come along and government has made a particular regulation, says people with a particular disease cannot move out of a particular area, and you may come along and say, well, I don't think that this is necessary. The test is necessary, so you go to the courts to argue whether that particular law is necessary or not. And that's how the test of limitations are applied. And I'm giving a very simplified version of this. And throughout the world, that's also accepted by the various UN organizations. And the test is of necessary. The next major amendment is Section 12. Now, we have put in a provision here, in respect of rights of arrested and detained persons. Now what we are saying is that you don't not only have the right to communicate with a legal practitioner of his or her choice in the private practice, where he or she is detained, but if he or she does not have sufficient means to engage a legal practitioner and the interests of justice so require, to be given the services of a legal practitioner under a scheme for legal aid by the Legal Aid Commission. So there are many people, for example, even today, if they are arrested, whether it's for being drunk and disorderly or any other offense, alleged offense, they may not necessarily be able to afford a lawyer. What this constitution does is makes it incumbent that that person has access to services from the Legal Aid Commission. With the interest of wider practice and indeed enforcement of justice, we need to make that available. See, many times people talk about, well, everybody has a right to get a lawyer, but in practical terms it does not translate into anything. Because if you are poor, you obviously don't get it. If there's no state resources allocated to that particular service, then obviously you won't get it. So this means whichever government comes or is formed after the 2014 elections and thereby subsequently, they always have to ensure that Legal Aid Commission has enough funding. Previously, as we found, back in the 90s and 2000, whatever they felt like at the end of the year, they would give Legal Aid Commission. So this makes it imperative for them to fund Legal Aid Commission. And of course, it means a practical application of access to justice, and indeed one may argue rule of law. Rights of accused person, again, in Section 14, we have put in Legal Aid Commission there to defend him or herself and be given access to Legal Aid Commission. Of course, legal aid is not going to be available to somebody who's earning $50,000 a year. It's made available to somebody who qualifies to be the recipient of legal aid assistance. And you'll see, for example, throughout, if you turn to 17, we put the test there, 17.3. It says, to the extent that is necessary, a law may limit. Freedom of assembly. To the extent it is necessary, a law may limit or authorize limitation of the rights mentioned in the interest of national security, etc. Now, we'll go on to the next major amendment. Of course, the equality provision, which is Section 26. In Section 26, as you know, we had already a fairly large unfair discrimination provision. Please go up. Yep, over there. So equality includes the full and equal enjoyment of all rights and freedoms recognized in this chapter or any other written law. A person must not be unfairly discriminated against, directly or indirectly, on the grounds of his or her, those various characteristics. So if you go up, now we, as you know, had for the first time in the draft constitution, in Fiji's history included, for example, culture. It was never there before. We had included for the first time your marital status in pregnancy, whether you were pregnant or not. So you cannot be unfairly discriminated against on any of those characteristics. We have also now included conscience, sex, and expression. We had submissions made on that. So they have also been included. So you can see very wide grounds of where a person cannot be unfairly discriminated against. Now, we've also, as you know, for those of you who may not have picked this up earlier on, that this also applies to the private sector now too. Previously, certain clubs could, for example, discriminate against women from coming to their clubs. Now, that's not allowed. I think one of the club's practices there at the moment that women cannot go to one section of the bar or the pub. Now, however, there are obviously certain exceptions to this. So one of the exceptions being that a law or administrative action taken under a law is not inconsistent with the rights mentioned in the section on the ground that it appropriates revenue or other money for particular purposes, imposes a retirement age on a person, imposes a restriction on a person employed or engaged in a state service, or confers on them a privilege or advantage not imposed or conferred on other persons. And also, of course, makes provision with respect to adoption marriage. So what it basically says is that the law of marriage will prevail over the unfair discrimination on sexual orientation. So in other words, if somebody is gay or homosexual, whether male or female, they cannot come and say that we need to be married because you have an unfair provision there. What this says is that the law of marriage will take prevalence over that particular provision. In the same way, we have now included this provision. To the extent necessary and without infringing the rights or freedoms set out in any other section of the Constitution, a law or administrative action may give effect to the communal ownership of Itauke, Rotuman and Banabal lands and access to marine resources, or the bestowing of Itauke, Rotuman and Banabal chiefly title or rank. So what that in practice means is, as you know, that there are certain areas where people may say, okay, you know, because maybe a chief has passed away, or we have decided for the next 1 month we're not going to do any fishing in this area. That's an initiative the village may have undertaken. You cannot, then you may have a regulation that allows them to do that. You cannot have somebody coming from another village or any other person saying, no, this is unfairly discriminating against me. It's my right to go and fish here. So that gives that protection for communal imposition of those sorts of practices. In the same way, for example, the NLC may say, Mr. X will be the chief. Mr. Y cannot come along and say, well, this is unfair discrimination because, you know, I want to be a chief too. But there are certain rules and procedures that need to be followed that's based on customary practices. So this allows for that to take place. It's a protection of those customary practices. So we've included that, you know, just to give it that that authority, just in case there's a challenge to that. Now, Section 27 is what we had talked about, that how land rights were protected, that the state could only access land if there was consent by the landowners or any other landowner, whether freehold or Itauke. And of course, some of the submissions we received, people say, well, that's fine, but we want it clearly enunciated. And we said there are already existing laws. So we've taken that on board and we've put that actually as a separate provision. So if we go to Section 28, which is the new one, which is completely new, so it says, the ownership of all Itauke land shall remain with the customary owners of that land, and Itauke land shall not be permanently alienated, whether by sale, grant, transfer, or exchange, except to the state in accordance with Section 27. Section 27 is, it says how the state can acquire land. the state can acquire land only for the purposes of, for public use. So if the state, for example, wants to build a new road, if it's a freehold land or if it's Itauke land, they'll go and say, look, we need it for public purpose, the rules allow for that, the laws allow for that, we'll pay you fair compensation. And then that is used for public purpose. Now, that already had existed in law, but we put it within the Constitution itself, quite clearly. We've then gone one step ahead and said, which was never done before, any Itauke land acquired by the state for a public purpose after the commencement of this Constitution under Section 27 or under any written law shall revert to the customary owners if the land is no longer required by the state. See, previously what used to happen, and even till now, until February of this year when the Prime Minister changed the law, previously what used to happen is the state may come along and say, okay, we need this land to build a jetty or we need to build a road. So that when the state got the land, it became under the Crown land, under the Crown land framework. So that land in fact became permanently alienated because it went to the Crown. And as you know, the issue with the Momi was they did precisely that, and as soon as it became Crown land, because as you know, you can convert Crown land to freehold. So they brought it from Itauke, Crown to freehold. What we are saying is that if the state acquires it for public purpose, if it no longer requires it, say assuming they've got some land to build a road, and they built the road. 10 years later on, they may say, well, you know, this is actually a flood-prone area, we don't want this road, we're going to build a new road. They have to give that land back to the Itauke landowners. That's what it says. So it gives protection to the ownership of the land. Now, subsections 3 and 4 is exactly the same for the Rotuman lands. Subsections 5 and 6 is exactly the same for Banaban lands, because all communally owned. So it gives them protection also. Completely new section. Another new section that we put in place is the protection of rights and interests in land, which is essentially protecting people who are leasing lands. So all ownership of land and all rights and interests in land, including land tenancies and leases that existed immediately after the commencement of this Constitution, shall continue to exist under this Constitution. So for example, if some of you may be living on land that's leased from the Crown or leased from Itauke Lands Trust Board, you may have a house on it. So what it basically says, whatever the tenancy agreement is you've reached or signed up, that continues. So it gives you protection. All land leases, lessees and tenants have the right not to have the lease or tenancy agreements terminated other than in accordance with their lease or tenancy agreement. So in other words, if you've got a lease agreement with DLTB or Crown Land, that is the agreement that you abide by. Nobody can come along and make a new law and say, okay, we're going to boot you all out. You can be booted out, but only under the tenancy agreement. If the tenancy agreement says for you to continue to be a tenant, you need to pay your lease every year, and if you haven't done that, obviously they can terminate it. But the protection is that nobody in Parliament can come and overturn that or make a law to get you out. And any amendment to any law governing lease or tenancy agreement shall not adversely affect any existing lease or tenancy agreement. There may be changes made, but it cannot adversely affect an existing tenancy. All land that existed as freehold land immediately before the commencement of this Constitution shall remain as freehold land, unless, of course, you sell it or is acquired by the state for public purpose under Section 27. So it gives those people protection too. Now, this is a new one altogether and very, very uncommon. As you know that in all Commonwealth countries, anything below 6 feet belongs to the state. And that is the legal philosophy that we inherited in Fiji and has in fact continued in our laws. And in fact, it was not changed after independence, nor after 87, nor after 2000, but we've now changed that. What it says, it's very important to know, all minerals in or under any land or water are owned by the state. Now, minerals definition includes, of course, natural gas and other things like that, are owned by the state. So it's owned by the state. Provided, however, that the owners of any particular land, whether customary or freehold, or of any particular registered customary fishing rights, shall be entitled to receive a fair share of royalties or other money paid to the state in respect of the grant by the state of right to extract minerals from that land or seabed in the area of those fishing rights. A written law may determine the framework for calculating fair shares under subsection 1, taking into account all relevant factors including the following: any benefits that the owners received or may receive as a result of mineral exploration or exploitation, the risk of environmental damage, any legal obligation of the state to contribute to a fund to meet the cost of preventing, repairing or compensating for environmental damage, the cost to the state of administering exploration or exploitation rights, and the appropriate contribution to the general revenue of the state to be made by any person granted exploration rights. So what it basically means is that the Constitution says that wherever you extract minerals from, whoever is the landowner of that particular place has to get a fair share of the royalties that the government gets. There are of course certain expenses the government may incur up front, and that needs to be taken into account when deciding how the distribution will take place. But a fair share must be undertaken. So for example, if a company is going to put up start a mine, there may be certain things the government may need to do, to expend money, to ensure, for example, the environment is taken care of. So that needs to be taken into account, but for the first time, the landowners will get a fair share of the royalties. So that is a very significant shift in the legal framework, not just in Fiji, but within the Commonwealth also. The Section 31 is a new addition. Conversational and contemporary Itauke and Fiji Hindi languages shall be taught as compulsory subjects in all primary schools. There's been a lot of talk about how people do not necessarily aren't necessarily able to understand perhaps some of the interactions that take place on a daily basis. If people knew each other's languages, then it would create a lot more understanding, and you're able to share your jokes. That creates a lot more harmony, etc., whatever it may be, in respect of increasing communication. And so it's up to primary school, it's compulsory. And you note that we put Itauke and Fiji Hindi, which is very different to the standard Hindi that they speak in India. So Fiji Hindi is very different. I think if you go to Ba, there are people who speak all three languages, or wherever it is in the Western Division, and they don't speak the Hindi spoken in India, but they speak the Hindi spoken in Fiji, which is Fiji Hindi. The other, Section 45 is the next major amendment that has taken place. More administrative than anything else. The Human Rights and Anti-Discrimination Commission, the membership has been enlarged. Normally, as you know, it used to be 3. We've now enlarged it to 5. And the appointments of the commission will now be carried out by the Constitutional Officers Commission, which you will see that we've included. The Constitutional Officers Commission consists of a team of people which I'll talk about later on. And the commissioners are appointed by the President on the recommendation of the Constitutional Officers Commission. The amendments in that section, again, in subsection 7, are more administrative to give it more independence. So in the performance of its function or the exercise of its authority and powers, the Commission shall be independent and shall not be subject to the direction or control of any person or authority except by a court of law or otherwise prescribed by written law. So guaranteeing more their independence. They have the power to appoint, remove and discipline all their staff. They have the authority to determine all matters pertaining to the employment of all their staff, the terms and conditions of employment, qualification requirements, salaries, benefits, etc. So a standalone organization to give it that independence. And of course, which is really important, is subsection 11 and 10, the salaries, benefits and allowance payable to any person employed in the Commission are a charge on the Consolidated Fund. So they have some may say a preemptive right on the Consolidated Fund. And Parliament shall always ensure that adequate funding and resources are made available to the Commission to enable it to independently and effectively exercise its powers and perform all its functions and duties.